Hello, everyone, and welcome to Team TSI's training today. We are so excited to present some great information to you today. We have our expert industry training, and today it's revisiting the independent IDR process. With that, we're going to do the housekeeping. So, if on the housekeeping slide, you'll notice that we've got some examples of what it looks like to ask questions. And I also want to encourage you to look at your GoToWebinar panel and find the question line and the handout line. In the question line, when you click on that, it will open up and look like my sample number 2, and that's where you'll type your question in for the staff. You'll hit send, and we'll receive your questions. We'll be monitoring your questions throughout the training, even having our experts answer some of your questions behind the scenes, and we'll save some of your questions for the end. Also, we included the handouts in the GoToWebinar panel, and we sent you links in your reminder email that you received earlier. So hopefully you received the handouts and you have already been able to print them. If for some reason you're having trouble getting those, let us know in the questions and we'll be happy to send those over to you. So now I want to introduce your amazing team today. And if you have not had the opportunity to meet each of the people that are up on the screen right now, this is just an amazing team. And you're seeing that not only by the information, but the reports and everything that's happening in the Team TSI portal. So our guest speaker and one of our experts that really, it just makes a huge difference in all of the regulatory information that we do is Hugh Heaton, and he's going to be the presenter today along with our Team TSI experts, which include Greg Seipel, Pat Newberry, and Jill Pugh. You'll hear from each of them and even potentially have answers to some of your questions throughout today's training. So behind the scenes, myself, Dahlia Croft, and my colleague, Kelsey Little, you'll also see our names if there's anything that we can help you with, or if you're not able to, again, get those handouts, we'll be happy to send those over to you. And if there's anything else that we can do, we'd be happy to do that. So with that, I want to thank you all for attending today, and I'm going to turn it over to Greg. Thanks, Greg.
Thank you so much. So thank you so much for joining us for this presentation and revisiting the independent IDR process. And you know, as the title slide basically says, it's the impact on the COVID-19 reporting and the new infection control enforcement actions are sort of what brought this to light to say, when you look at what's happening now in the industry and in the environment in response to the public health emergency in COVID-19. And of course, you know, the added NHSN reporting, the monitoring that's going on from a CMS standpoint, the issuance of federal citations and civil money penalties attached to it as well. The ability to dispute those findings in the event that they're in error is somewhat vital, especially at this point in time. And not everybody is as intimately familiar with the independent IDR process as we are with the IDR process, you know, given this is a federal it's designed to be a federal process as well. So there's some learning objectives for this session. And you know, one of the things we want to basically do is just go over the independent IDR, IIDR process in and of itself, as well as the benefits of using it and how the process flows and you know what you can hope to achieve and gain through this. We really need to focus on the importance of understanding the COVID-19 reporting requirements, as well as the new enhanced infection control enforcement process. The penalties that are coming along with all of that is, again, sort of one of those things that predicated the need to revisit this and make sure everybody was intimately aware of what your actions that you can take in response to citations that you may have received in error. Definitely need to discuss the independent IDR timeframe requirements. You know, you have to submit within a certain time frame. There's consequences, of course, if you don't. We're also going to make you aware of actions that are considered an invalid use of the independent IDR process, what you really can't put inside of an independent IDR. And then, of course, There's the additional types of independent IDR reviews. What are the costs that are associated with that, and whether or not legal counsel is going to participate, and source associated costs with that stuff as well. You know, we'll look at things depending on what the outcome of the independent IDR is. And, you know, if you're successful, you know, there's vitally important, you request a new plan of correction, you need a correction made to the public record. We're also going to go through what it means to kind of prepare and submit the relevant documents for an IIDR to ensure that you've got all of your ducks in a row and you're kind of leading them down the primrose path of your argument. And again, IIDR, the process in and of itself, is for any type of a federal dispute, but we're going to kind of try to tie this down to the COVID-19. We'll talk about individuals that may be allowed to attend the independent IDR hearing as well. And then, of course, one of the things that you'll have to decide is whether or not it's valid to do it or proceed with any independent IDR, or, you know, what reasons there may be not to proceed. What are the risks associated with an independent IDR? The person that's really going to lead us through this is Hugh Heaton. And again, for those of you who have, you recognize that name, leader in the industry since the, I don't want to date you, Hugh, but let's say the mid-70s, with developing policy and procedure. If you are familiar with the Heaton manuals that are still now available through MedPass for infection control, for clinical processes, for operational processes, Hugh has been a force in the long-term care industry for years. Nobody that I know with more knowledge and experience in this industry to teach and kind of show the way for some of these things. So that being said, I'll turn it over to you, Hugh, and thank you again so much for doing this.
Thank you, and hello, everyone. It's certainly an honor to be a part of this presentation in Team TSI. I want to start out with, if you hear some loud rumblings in the back, it's because there's a thunderstorm going on. So just ignore all of that sounding that you hear. And I want to start by just saying how much I appreciate all the work that you and your staff are doing, and under the very difficult situations and times. And I really appreciate what you're doing to provide the profession with quality care and taking care of the residents and your staff. This particular session is a very complex process. And what we wanted to do, after, as Greg mentioned, when you're looking at what the new focused infection control survey process is about, and then the new enhanced enforcement penalties, we wanted to look at those just briefly to reemphasize the importance of taking a look at the independent IDR process, and even the IDR process will play some roles in this when a CMP is not imposed. But the reason that we chose to focus on the independent IDR is because of the civil money penalty process. The first thing I want to look at is, Dahlia mentioned this, is the handouts. I think there are 3 on there, but I wanted to just briefly go through what your handouts have. They contain all of the support information that provides the support of this particular training process and where we got the information, and to have that at your fingertips. I believe the PowerPoint slides are there as well. So you can use the PowerPoint slides and this handout together if you want to do that. The first part is the participant. Let me go back to where I want to get to. It's the part 1 is dealing with the slide presentation. If you want to take this guideline and to train your staff further, or to review with your staff, or let them review the information, you'll find that the note pages and I will use these as we go through them. You will have the same information that I'm going to provide to you. You'll notice that also everything is linked. So if I want to look at handout number 1, I can do that quickly just by clicking on that, and that's the participant handout that Dahlia mentioned. So you have all of the slides. Everything in your handout is bookmarked. So if you want to look for a particular slide, you can do that very quickly just by going through here and like I say, when it comes to providing a particular handout, you'll see that information on that particular slide as well. And I will be using this information in the session today. The other part is the handouts, and I think you will find these extremely helpful. Handout number 1 is the participant session outline. These are the slides that we're going to go through. These are the slides that is in the PowerPoint presentation itself. So if your staff, whoever is attending your training program that you want to conduct, they have the same information that you're looking at, and we provided a note page. The second part is the actual regulatory process. This is Chapter 7 of the State Operations Manual. These have been in existence since January of 2012. There have been no changes to this process in the State Operations Manual since that time. So all of the process, all of the slides that we're going to go through, the process that we're going to go through with this information comes from the regulatory process. It also has, as a part of it, paragraph 7500, which deals with a directed plan of correction, and that's one of the newest enforcement penalties, is the directed plan of correction, and we will talk about that. But these are the regulatory guidelines that CMS and states have to use in implementing or issuing a directed plan of correction. The information that has to be furnished to the state ombudsman. So all of the Chapter 7 of the survey process is here. We also have provided QSO letter 20-29, which deals with the reporting requirements. And we will be looking at these as we go through the process and coming back to some of the handout material. The second one is the QSO 20-31, which drives the new enforcement penalties for infection control deficiencies. Currently, this letter only applies to survey tag number F880. That's what CMS says. I'm not sure if it will stay that way or not, but currently that's the tag number that they're going to look at and as we go through. Handout number 5 is as we go through the process and look at you're completing an independent IDR or requesting an IDR. In the session, we will look at time frames. I provided this case. This is an actual case. Omitted the name of the facility and any identifying information about the facility, but this is an actual court case where the facility appealed the decision of the independent IDR, and they were denied a DAB hearing, an administrative law judge hearing, because they filed it late. And this is a court case that's got a lot of information that will be helpful to you in looking at why some of the penalties or some of your appeals process is denied. Handout number 6 is really a good handout. And we'll discuss it as we go through. This is a form that we designed to give you some guidance on, do I want to do an independent IDR? So this is a preliminary worksheet for you to just write down, this is the deficiency I'm looking at, these are the things that occurred, here are the things that I need to submit. Do I have the support, the documentation to support challenging the deficiency? and one of them, of course, is a blank form, and it's pre-fillable. So as you go through that, these are just some of the things that the handouts will provide to you, and really enhance the training program. And we will discuss these as we go through them. Also, if you want to keep a documentation of doing a record or doing a training program for your staff on this particular topic, all of the record keeping forms are here, and they're all pre-fillable, even a certificate of completion. So your handout has a tremendous amount of information. The other one that we have attached with it, and I think Dahlia put this as a separate one, and we will discuss the usability of this particular document as we get into the process. This is applying for an EPOC, and your facility may already have one. If you don't, you will need to get one, because all of your communication from the state survey agency is now going to come to this account. And so you may want to look at that, and your corporate office may have an account. It talks about that, but these are just some instructions that you may want to look at if you don't have one or if you're not sure. So with that, I'm going to go back to our slide presentation. And I have to do all this footwork to get us back where we are. The first thing I want to do is just try to do just a quick overview of some of the things that Greg touched on as well. It allows the facility to dispute only those deficiencies for which a civil money penalty has been imposed and will be collected and placed in escrow. So that's the only time you can do an independent IDR. It's different from the IDR process. The IDR process lets you challenge any deficiency, but you cannot seek an independent IDR unless you receive a notification from CMS of your eligibility. That goes back to the EPOC. If CMS is moving away from written notification through the mail, it's going to be sent directly to your EPOC account, which is a part of your CASPER file. If you've got a CASPER account and you don't have an EPOC account, it's really easy to do that. You don't have to go through completing all the paperwork again. But this is where your notice is going to come. The facility's request for an independent must be made within 10 calendar days of the receipt of the offer. So it's 10 calendar days, not 10 business days. So weekends and holidays count as part of the 10-day process. That's very important. The time frame runs concurrent with the submission of the plan of correction. You have 10 calendar days, and these run concurrently. So if you're going to request an independent IDR, it has to be within 10 days of your receiving this information. You must submit a plan of correction within 10 calendar days for any deficiency that you're not challenging, or that you are not being, you don't have an independent IDR is permitted. The written notice comes from CMS, and it should include information about the process and the documents that they want you to submit. I have seen some of the requests, some of the information from state survey agencies to facilities that provide that information. You need to do this. These are the documents we will accept. You need to do it at within this time frame. Another important reminder is that of requesting a hearing with the DAB, or the Departmental Appeals Board, before an administrative law judge. This is a separate process from the independent IDR. You only have 60 calendar days from the date you receive the written notice of the imposition of an enforcement action. Now, the appeal work you can appeal a CMP, a DPNA, any deficiency, even in an IDR. You can still request a hearing before an administrative law judge. but you only have 60 days to do that. The fact that you have requested and are participating in an independent IDR does not suspend the 60-day time frame, nor does it delay the imposition of any CMP or other remedy. What's important about that is, and that handout number 5 that we just looked at is a court case that provides the information about how the facility was denied that. The facility actually participated in an independent IDR. They won parts, they were successful in parts of the IDR, but the state survey agency did not send them any notification of that until after the 60-day time frame had ended. The facility applied for an appeal. The departmental appeals judge denied the request because it was later than the 60-day, and you can't use the fact that you are in an IDR or an independent IDR. You can that does not suspend the time frame. So that's very important. But let's look at the benefits of using an independent IDR. It reduces the impact on the 5-star rating. That's very important to you to have the removing or decreasing a scope and severity can improve the status of the facility on the nursing home compare. Your financial institutions, your insurance carriers, other people look at your nursing home compare rating. Financial institutions look at your complaint history, especially the complaint history. So that information is very critical, and having that removed certainly helps in that process. Deficiencies removed will not require a plan of correction or a follow-up. When survey tags or scope and severity levels are decreased, the facility may have less exposure or liability for certain claims, and that's always good. Individual license of the administrator and the facility would be better protected, especially when there is a valid reason to dispute the tag. Now, I want to interject something here that our team discussed yesterday, is that CMS has a database of the facility's administrators and DON, the management team. They have a database of everywhere that administrator has worked and the dates of employment, every facility. They also have a second database of that administrator's history in that facility. What kind of surveys did they have? So when you look at the benefits of doing this, it's the benefits of your license. And so we encourage you, take advantage of the independent and the IDR process. It's critical to you. The facility has an opportunity to review its policy and procedures when analyzing the deficiencies and can make determinations as to the benefit of modifying it. You may see, if I do this, this might correct that. And that's always helpful, whether it's one policy or a dozen. But one of the major things that we want to look at today is challenging F884 citations and other related infection control deficiencies to prevent the enhanced enforcement actions for infection control deficiencies. Those enhanced penalties apply at any infection control deficiency at a scope and severity level of D or above. Now, this is not a COVID-19 survey process. These penalties apply to any survey, whether it is a standard, whether it's a complaint. This is going to be the new norm for handling infection control citations. So you want to challenge those as much as you possibly can. So what we want to do now is take a look at the COVID-19 reporting and the enhanced enforcement guidelines and look at the significance of those and why you should use the independent IDR. QSO letter 20-29, and many of you are familiar with that letter. It is the QSO memo that provides information to the facility on reporting information to CDC on a weekly basis, and how the facility is to report information to their residents and their families and their representatives. You're all aware of that information, but we want to look into it a little bit more, and the failure to report the data can result in an enforcement action. Let's look at just COVID, the F884, which is a new tag number that deals with reporting information to CDC. It's conducted off-site by CMS using the weekly data reported to CDC. You report the information every Sunday. Every Monday morning, that information is provided to CDC, or to CMS, I'm sorry. CMS takes that information and they look at data and determine how if there are penalties to be assessed, if so, where, and then they notify the state agency of that information. If you're cited, if you fail to report the data timely, it's an automatic F-level citation with a one-day CMP of $1,000. And CMPs are increased by $500 for each week data is not submitted. And I want to just pause there for a moment to tell you that how that particular citation works. F884 is a federal citation. It is reviewed by CMS only. Only CMS regional office can cite F884. The state survey agency cannot do that. Only CMS can cite that. Therefore, it's a federal survey. It becomes a federal independent IDR, and that's different. But the way the penalties work is if you fail to provide it timely, every week, the first week is $1,000. The next week is $1,500. The next week is $2,000. So it's a $500 added to the $1,000 every week. It's a cumulative total. If you are failed to submit data, or it didn't go through, or it didn't pass the quality check, and say you had provided the information correctly the week before, the citation, the way that the penalty works is that if you skip a week, so you had a $1,500 penalty, you skip a week, and then you fail to submit it again, the penalty doesn't go back to $1,000. They go back to the $1,500 and add the $500 to it. So that penalty for that week is $2,000. So it's a cumulative total, depending on whatever the last civil money penalty was. That gets a little confusing, but that's the way they do that. And one of the reasons you want to look at that is CMS is having, and CDC has reported they are having issues with the data being reported, or you may report it, it's a problem with CDC, or it didn't go through. The facility gets a notice. You didn't timely report your information. Facility has all kind of documentation that they did do that. But what the facility has to do is file an independent IDR to correct that. What CMS does is they post this level F citation, the 2567, is posted to your Casper account. It is not sent to the facility by mail. It is sent to your EPOC account. And you need to check that every day. Every day, check that, because that's where the information from CMS is going to be, especially this one. And the letters tell us that That's where it's going to be posted. So even if you report it correctly and you have all the documentation to support it, you are automatically receive a level F citation, and you need to file an IDR, independent IDR, to dispute that. F885 is information that the facility uses to report to the resident, to the families, and it's conducted on site during the focus survey. I had a friend of mine who is an administrator in another state, and they sent me some information of what the survey team is asking for in addition to other information that you have to provide them. For example, on the entrance conference worksheet, they're asking for this piece of information: proof of notification related to COVID-19 sent to residents and families. So they want to see that, the proof of your doing that. If the surveyor finds noncompliance, a citation will be entered on the 2567. And this comes from QSO letter 20-20. So it's important that you look at this information, especially in your EPOC account, and you only can file an independent IDR. And that notice will come from CMS, not from your state survey agency. So let's look at the new enhanced enforcement process for infection control deficiencies. This is a very stringent process, and currently it only applies to infection control. So this is QSO letter 20-31. It implemented new enforcement guidelines for compliance D or above with any deficiency associated with infection control. I sent a text or an email message to CMS wanting to know what did they mean by any deficiency. Was that all of the infection control citations? Was that have to do with the F945 training? Their response was that currently it only applied to tag number 880 because tag number 880 has so many parts. And so currently that's the only tag that this is going to apply to. So here's what happens. If the facility has had no infection control deficiencies over the last year, since the last standard survey, and the facility is cited at a D or an E level, remember this is no deficiencies in the past year, no current infection control. It's an automatic directed plan of correction. You have that information in your handout. If you're cited at an F level, that's considered widespread. The penalties are a directed plan of correction, a discretionary denial of payment for new admissions, and you have 45 days to demonstrate the compliance with the infection control. The directed plan of correction, you must also provide with the plan of correction, and you actually have to do a plan of correction, a 2567, even though the state is going to tell you what you're going to do. You're going to have to provide the corrective measures, and you also have to provide, as a part of the corrective measures, a root cause analysis. They want to know what you found, how you're going to correct it, and what measures have you implemented to monitor the success of that. And that's all part of the directed plan of correction and root cause analysis. You have 45 days to correct it, and there will be no visit based on the information that I'm receiving from the facilities and from the state agencies. They are not going to do any revisit prior to this time to determine if you've corrected it. you're going to have to correct it, and then they will come and do a revisit after the fact to determine whether it's actually corrected or not. So that's if you have no deficiencies. If you've had one deficiency in the last year or on the last standard survey, and this year you're cited at a D or an E, it's still the directed plan of correction, denial of payment, 45 days to demonstrate compliance, and up to a $5,000 civil money penalty. That's at the discretion of the state or CMS. If you've had one in the past and you're cited in F level, it's the same penalties, but it's a $10,000 civil money penalty. If you have had two or more since the last standard survey in the last 2 years, it is still the directed plan of correction, denial of payment, 30 days to demonstrate, and a $15,000 per instant, or CMS can make it a per day as long as the total amount exceeds $15,000. So these penalties get very strict. The further you go, the higher the scope and severity, depending on your past history. Your past history is everything. One of the things that the survey team has now when they come into the facility, they have on their computer a new F80 icon button on their computer. When they select that button, it automatically populates the facility's past F880 compliance. So go back and look at your past compliance history, especially for F880, because that's where these enforcement penalties are going to be assessed. They focus on this particular tag number. So you see, as it goes up, it's $20,000, and you have 30 days. But if they cite the current at a GH or I, regardless of the past compliance history, you have these penalties. You have 30 days to demonstrate compliance, and CMS then determines what the civil money penalty or other penalties will be. CMS determines that. If you're cited at a JK or L, they've added one. It's a temporary manager or termination, imposition of all of these things, and you only have 15 days to correct it. What's important to remember about the significance of a DPNA and a temporary manager is that you automatically lose nurse aid training program when those are implemented, as well as civil money penalties. But if the DPNA is actually assessed, then you automatically lose your nurse aid training program for 2 years. Now, there are rules, there are some regulations proposed that's going to address that, but they're not in force at this time. So let's look at the time frame now that we've looked at these two issues, and we chose those because they have such significant impact on your facility's rating. So as we look at that, you have the time frame for submitting it. It must be, you can, for each survey that cites deficiencies for which a civil money penalty has been imposed, that will be collected only upon the facility's timely request. If you do not submit it within 10 days, you're not going to get it. The facility must submit its request within 10 calendar days. The facility must submit it in writing. And when you get your 2567 from CMS, it will have information about whether you are eligible for an independent IDR or not, and when you must have it. If it's mailed, the postmark must verify that the request was made within 10-day time period. So that's very, very important. Include the documents that's outlined in your notice. If it's got medical record information in it, if it's got resident information in it, be sure that it's redacted. And your notice will have that type of information, or it should. If it doesn't, you need to contact your state agency. Time frame for completing an IDR. Now, we know how well that goes with CMS. The time frame for completing the independent IDR is supposedly within 60 days of the facility's request. That doesn't always happen. But notice this next note. Every effort must be made to comply with it. However, that however is big. Failure to timely complete the independent IDR process does not invalidate the deficiencies or delay in any remedies imposed. So if CMS doesn't finish this within 60 days and get that information back to you, the penalties and the deficiencies are imposed. The independent IDR process is considered completed if a facility does not timely request or choose not to participate. So if on day 11, the independent IDR process is considered completed, or when a final decision has been made, a written record has been generated, and the state survey agency has sent written notice of the final decision to the facility. An unchallenged deficiency is deemed final. Remember that. If you don't challenge it, it's final. Substantial noncompliance with one participation requirements can support the imposition of a penalty. So if you decide to challenge within that 10 days, everything that you're going to challenge about that deficiency has to be included with that. Because once that 10 days has ended, you cannot add anything else to it, any other record, unless you go before an administrative law judge, and the administrative law judge can rule yes or no. So an unchallenged deficiency is final. Invalid use of the independent IDR. Greg touched on that. What you cannot do, you cannot challenge the remedies imposed against the facility. You can challenge the deficiency, the survey tag number, but you cannot challenge the remedy. You cannot question or issues from a previous survey. Nothing from a previous survey will be permitted. You cannot decide a deficiencies when a CMP is not imposed. So if it's something other than the CMP, you cannot challenge that. Now, state agencies that have independent IDR may permit an independent IDR for penalties other than a civil money penalty. They have the option to do that. However, the state can charge for that process. So you may be able to. It depends on what your independent IDR process is for your state. You cannot challenge the scope and severity of a deficiency unless it is a substandard quality of care or immediate jeopardy citation. It's the only time you can challenge the scope and severity. You cannot challenge survey findings that have already been the subject of an IDR unless the IDR was completed prior to the imposition of the civil money penalty. And all of that is addressed in your handout in Chapter 7. You'll see that information. You can't challenge the alleged failure of the survey team to comply with the requirement of the survey process. You can't challenge the inconsistency on the survey team. One says this, one says that. You cannot challenge that. You can't challenge whether the survey was adequate or inaccurate. You can't challenge that. And you cannot challenge the surveyor behavior or conduct. And sometimes you want to, because I've been involved with the survey process where the surveyors in my buildings uh, had attitude problems, and I'm sure that you've had that as well. The types of review. There's three types that you can have. You can have a written desk review, a telephone review, or a face-to-face meeting. You can have a federal independent IDR process. This is different from the state independent IDR process. In the case where a federal survey conducted solely by federal surveyors or its contractors results in the implementation of a CMP, the regional office will provide the independent IDR notice and process. And that go back to tag F884. This is a great example of that. You will receive the notice from the regional office because it is made by the federal surveyor. State surveyors do not participate in that. So, and the federal independent IDR process is a paper review only. So you have those types, and you can request which one you want. Cost to the facility. The state cannot charge you for the independent IDR process for deficiencies that are the basis for a civil money penalty, which is not collected and placed in escrow, or for deficiencies that led to the imposition of another remedy that is not a civil money penalty. A state is not required to provide the independent IDR. I just mentioned that. But they can. But they may choose or not choose. They may decide to do it as a part of the independent IDR process. The participation of your legal counsel. The attendance of your legal counsel at an IDR, independent IDR, or any IDR, is a state decision. Each individual state makes that determination. They just can't show up. Should the state permit the legal counsel to participate, you must notify the state that your legal counsel is going to participate, and you need to do that when you're filing your appeal or filing your request for an independent IDR. You need to determine that and put that information in there so the state will be aware of that. The cost of the legal counsel from the state or the facility belongs to whoever is using their legal counsel. Notifying involved residents and ombudsman. When you file an IDR or an independent IDR, once the facility requests that from the state has to notify the involved resident or resident representative or residents, whoever is on the statement of deficiencies. That's who they will contact. They can't contact anyone outside of that. It has to be only the information that's contained on the statement of deficiencies. And they have to contact the long-term care ombudsman, that they have an opportunity to submit written comment. The state is encouraged, I like that word, the state is encouraged to request from the ombudsman specific information based on direct involvement or knowledge about the issues being disputed. But notice what the next one is. They are not supposed to use any just general information about the facility. It's not, well, this facility doesn't do this or this facility doesn't do that. What they're supposed to be looking for is only information that's relevant to the deficiency that you are disputing. Be sure when you're looking at participating in that and you're looking at the information that they're providing, that they're not just chasing rabbits, that they are only addressing issues that is relevant to that tag number and to the citation that's on the 2567. Now, this one is probably one of the most critical parts of the independent IDR or IDR, either one. It's the plan of correction. based on a final independent recommendation and final state and CMS action if one or more deficiencies on the 2567 has been changed, deleted, or altered. The facility has the option to request a clean or new copy of the 2567. Pay close attention to this one. The new copy will be the releasable copy only when a clean plan of correction is both provided and signed by the facility. That's a critical piece of information. If you do not request a new 2567 and submit a new plan of correction and sign it and date it, the original 2567 is then disclosable. So what that means is, if you've been successful in an IDR or an independent IDR in the past, you did not submit or request from CMS a new 2567 and submit a new plan of correction. Even though you may have won that dispute, if you did not ask for a 2567 and resubmit it, that deficiency is posted to CASPER. The original 2567 is posted. So when you're looking at your 2567 or you look at your CASPER information or nursing home compare, and you might find that, well, this deficiency, we shouldn't have that deficiency. If you remember on one of the slides we talked about an unchallenged deficiency is a final deficiency. The same thing holds true here. That is a final decision, and it cannot be removed. What CMS does is on the survey process, they post all of the deficiencies on the 2567 that they send to you is posted to the Aspen system. If you file an independent IDR process or IDR process, it goes into an informal dispute resolution database. That information is recorded. If you didn't submit or you didn't correct the plan of correction, then the original information that they uploaded to Aspen then is uploaded to CASPER, which is then posted on Nursing Home Compare. So be sure you check that. That is so critical. And any form or plan of correction that's revised or changed as a result of the IDR must be disclosed to the long-term care ombudsman. Document preparation. This is very critical. What you should include, the tag number. Now, when you get your notice for an independent IDR, this information really should be as a part of the plan, because according to Chapter 7 of the SOM, the state is to provide this information to you in writing. But even if they don't, this is what you need to prepare. What tag number are you disputing? The reason why you're disputing the tag. The reason why the scope and severity should be reduced if it's a substandard quality of care or IJ level. What your desired outcome is. I want it removed. Documentation that directly demonstrates that the deficiency is not sustainable. And we looked at, one of the things you'll look at is handout number 6. That's a preliminary worksheet that will help you look at what evidence am I submitting. Does it demonstrate that deficiency was not sustainable? The type of independent IDR format that's desired. I want a written review face-to-face if legal counsel is attending, and other data that may be required by the independent IDR plan. Every state is different. Submitting relevant documents. A form that is specific to the disputed findings. Blank forms should only be submitted to prove that a form existed at the time of the survey. Documents from appropriate facility records. For example, if the dispute regards a care plan that a surveyor found deficient, submit that care plan. Don't change the care plan. Don't add anything to it. Nurses' notes, physician notes, medication orders, and assessments. Any policies and procedures that drive that. I believe in the example of handout number 6, the example addresses all of these particular issues, the policies and procedures, in-service training records, the curriculum, the signature list. They don't want the whole thing. They just want to, and they'll probably tell you what they're looking for. But one of the things that I'm seeing and hearing from some of the administrators and looking at some of the 2567 data is they are rejecting the plan of correction if in the in-service training program there's not a process for measuring the success of the training program. They want to see that in the plan of correction. I've been seeing some of that, and they rejected those that did not. Parts of the MDS signed and dated testimonials from resident family, but only as it applies to the deficiency, not about whether they like the RN or the DON or if they like the administrator. It's only testimonials about the deficiency. You may be required to submit a copy of the statement of deficiencies without a plan of correction. They may want you to submit that. They probably will ask for you to explain why the material was not submitted or shown to the survey team during the survey findings, for example, at the entrance conference. You should always make sure that the documents are in the original format, original form. Do not submit documentation that was prepared after the survey. Don't revise the policies and procedures, care plans, and in-service training records. I've seen court cases, appeals from DAB panels where the facility showed the surveyor infection control policies. During the survey, they appealed the decision and submitted a different set of infection control policies. And the administrative law judge rejected that. So make sure that all of the wording on the documents are legible. Illegible documents will not be reviewed. Follow the state's process for redacting resident identification information by all means. And let's look at what is usually determined evidence which is almost never relevant. Never. Time, event, or person other than the identified on the statement of deficiencies. If it's not on the statement of deficiencies, do not include it. If the residents or other residents that had similar situations but were not included on the statement of deficiencies, you can include that. Events occurring after the date of the statement of deficiencies. Any remedial measures, like I changed the policy after the alleged deficiency. Offers to pay medical expenses, you'll be surprised about that one. Past determinations of deficiencies, which shows a previous survey from another facility in which the same deficiency was removed during an independent IDR. You can't do comparative evaluations. And evidence relating to the statement of deficiencies which are not disputed. So it's only what is disputed. The burden of proof. The standard of proof is the level of proof required because the purpose of the independent IDR is to provide the facility with an opportunity to refute certain cited deficiencies. It is the facility that has the burden of proof of presenting evidence which can persuade the independent IDR of the necessary elements of the regulation were met. It's the burden of the facility. I'll give you an example. The issue with the F884 CDC citation or reporting weekly information. Even though The facility has done everything in its power to submit it correctly, and it's not being accepted through the CDC portal. The burden of proof does not lie with CDC. What the facility has to do is challenge the level F through an independent IDR, even though it may have been CDC or CMS's problems. The burden of proof falls on the facility. That's unfair, but that's the way it is. Attendance at an IDR normally will be your facility representatives and staff, survey team members, ombudsman, and involved residents. If you're going to have a face-to-face and a resident is involved, they're going to ask for the resident or legal guardian to be there as well. Legal counsel and others that may be permitted by the state. And one thing that all person will have to do is follow the HIPAA requirements. They can't participate in the IDR and then go talk about it because of confidentiality issues. But I want to take a look at this one. We're almost through. Questions that may arise concerning whether or not you should submit an independent IDR. These are some of the reasons why you shouldn't. Do I have an argument that is supportable and appropriate? Handout number 6 will help you do that. Are the time and financial resources needed to proceed with an independent IDR worth it? I think in today's legal way everybody wants to sue, I think, yes, it's worth it. Are there future hearings or litigation consequences? What are the consequences of the cited deficiency? What is the scope and severity of the cited deficiency? Will independent IDR create the potential for new tag citations? And will independent IDR create a suspect with regard to the evidence submitted? So that's a lot of material that we covered in a short period of time. We wanted to leave enough time for you to have an opportunity to ask questions. So if there are any, I'm open to that. Daria, Greg?
Thank you, Hugh. That was awesome. And Greg has actually gone in and answered some of these questions. So Greg, if you don't mind, I'd like to kind of turn it over to you to see if those questions, we should bring those up to the group, or if there's any other things we should cover today.
Well, there were 2 questions that were more related to the questions around NHSN reporting requirements and whether or not cumulative resets. I think it was the difference between F884 and F885 when there's new cases reporting to residents and families versus what's reported to the NHSN, and what really constitutes cumulative updates to the family, and whether a spell of wellness resets the cumulative clock or not. And there's really no clear delineation of that in the regulation, though when you go to the guidance for the surveyors in the COVID-19 focused infection control survey process, it does basically state one of the review questions for the server is whether or not the facility is providing cumulative updates to residents, representatives, and families at least weekly or by 5 p.m. the next calendar day when you have that 1 new case or 3 cases within 72 hours. So in regards to NHSN reporting, cumulative is always going to be from January 1st to present, however many total cases suspected, confirmed, whatever date is being reported since the first of the year. But in regards to reporting to families and residents and resident representatives, it does seem the reporting focuses on emergence of new cases, but it does have a qualifier in for cumulative without really explaining what cumulative is. So I'm not sure we had a perfectly great, wonderful, clear answer for that, but those were the 2 questions that basically had come about. We didn't really have anything specific to the IIDR process, though.
Okay. Well, I know that it was a lot of material to cover. But I think the handout will provide you with a tremendous amount of support information. And just to share with you, we are doing a 45-minute session on the enforcement process, the new enforcement penalties on August 4th. that you may, if you've not signed up, that you may want to, because we're going to go in depth of a lot of those particular questions as well. So I appreciate the opportunity to participate, and I hope it was helpful.
As always, wonderful information to share, and thank you so much for giving your time to be able to provide these educational sessions, especially as an industry update. So always the most appreciation. Thank you so much. Allie, any closing?
Thank you, everyone. I believe that completes our session, and thank you so much for the entire team being on today. And we really appreciate our partnership with each and every one of you. So thank you, everybody.
Thank you. Have a great day.